So, you've had one of those game-changing ideas and you're thinking, hey, this could be huge. But, before you start planning your victory lap, there's a really important step. In India, the law is super specific about what you can't patent. And trust me, some of these rules might actually surprise you. So, let's dig into that official no-go list. Right, so you've had that light bulb moment, that flash of pure genius where it all just clicks. But here's the real question. Does the law see that as a legally protectable invention, or is it still just a brilliant idea? And that's the exact line we're going to try and draw today.
To get the real scoop, we've got to go straight to the source material, India's Patents Act of 1970. You can think of this as the ultimate rulebook. It's the document that separates a cool thought from a concrete invention that can actually get legal protection.
Okay, so here's how we're going to break this all down. First, we'll get to know the rulebook itself. Then, we'll get into the huge difference between discovering something and actually inventing it. After that, we'll talk about what I like to call the no-tweak rule. Then we'll look at the big ethical lines the law draws, and finally, we'll see why abstract ideas and art are in a whole different category. All right, first up, the patent rulebook. What's kind of funny is that the law doesn't just define what an invention is. Actually, it spends a ton of time giving us a very, very clear list of what it is not. And the core of this whole thing, the part we really need to focus on, is Section 3 of the Act. I mean, think of it like a bouncer at a club. It has a list, and it lays out, right up front, all the things that are just not getting a patent. Period. Now, this next point is one of the most important concepts in all of patent law. It's the massive difference between a discovery and an invention. See, just because you found something incredible that already exists in nature doesn't mean you created it. And the law cares about that difference a lot. So, for example, you can't patent a law of nature, like gravity. You can't patent a plant you just stumbled upon in a forest. That's a discovery. What you might be able to patent is a new machine that uses the principles of gravity in a totally novel way, or a new medicine you developed from that plant. It's all about the practical application. It's about what you build with that discovery. The law also has, let's call it, a built-in reality check. It automatically says no to anything that's just plain frivolous or, and this is a classic, anything that claims to defy the known laws of nature. So that perpetual motion machine you've been tinkering with? Yeah, sorry. The patent office isn't going to be interested. Okay, so we get it. You can't patent something that already exists. But what if you just tweak it a little bit? Well, that brings us to our next big idea, the no-tweak rule. This is where the law gets really granular about what counts as a brand new invention versus what's just a minor facelift. Now, this is a huge one, especially for pharmaceuticals. The law says you can't just take a drug that's already out there, create a slightly new form of it, and get a new patent, unless you can prove it has an enhancement of the known efficacy. In plain English, you have to show it works significantly better. This is designed to prevent what's called evergreening, where companies make tiny tweaks to get new patents and extend their monopolies. And believe me, the law is incredibly specific here. It actually lists out a whole bunch of these chemical modifications, things like salts, esters, polymorphs, and it basically says, look, we consider all of these to be the same base substance. So unless your new version is a lot more effective, it's not getting a patent. And this no-tweak idea goes beyond just chemistry. You also can't get a patent for just mixing two things together if the result is exactly what you'd expect. The same goes for just rearranging the parts of a known machine without fundamentally changing how it works. The bar for what's considered truly inventive is, well, it's higher than that. Okay, so up to now, we've been talking about the technical side of things. But the law also steps back and asks a much bigger question. Is this invention actually good for people, for society? And that brings us to some pretty clear public and ethical lines that just can't be crossed. You can think of this rule as the Act's moral compass. It's a complete stop sign for any invention whose main purpose goes against public order or morality. This is the clause that would block a patent for something that's specifically designed to cause serious harm to people, to animals, or to the environment. The law also carves out some really important areas that it feels must stay open and accessible to everyone. For example, you can't patent a method of farming, you can't patent a new surgical technique, and you can't patent actual plants and animals. The thinking here is that these areas are so fundamental to life and well-being that they shouldn't be locked up by a patent. They belong to everyone. And there's one more big area that's off limits, and this one's all about national security.
A totally separate part of the law, Section 4, makes it crystal clear. No patents whatsoever will be granted for inventions related to atomic energy.
All right, on to our last section, and this one deals with the world of pure ideas. This is where the law draws a very firm line between an abstract thought and the kind of tangible, practical invention a patent is really meant for. And this leads us to a classic modern-day question. In our world, so much value is in software and systems. So what happens when you come up with a brilliant new business method or you write a game-changing piece of code?
Well, the Act is pretty straightforward about this. It states you cannot patent a business method, a mathematical formula, or a computer program per se. Now, that little phrase per se is absolutely critical. It means you can't patent the code by itself, just as an algorithm. By the same token, you can't patent a way of performing a mental act, a new way to play a game, or simply a new way to present information.
And the list doesn't stop there. Things like literary or artistic works, books, music, they're obviously out. That's what copyright is for. The law also specifically excludes the design layouts of integrated circuits. And this last one is really important. You absolutely cannot patent an invention that is just an expression of traditional knowledge, wisdom that's been part of a community for generations. So, after going through all of that, what's the big takeaway? The real aha moment, if you ask me, is this. A patent is not a reward for finding something that was already there. It's a reward for creating something, for building a solution that is genuinely new, actually useful, and isn't just the obvious next step that any expert in the field would have come up with. That right there is the heart of patentability. And all of this leaves us with this big, fascinating question that never really goes away. All these rules are trying to perform this incredibly delicate balancing act. How do we protect and reward innovators for their hard work without letting crucial knowledge be hoarded and kept from the public good? Finding that perfect line is a constant challenge, and it's one that gets renegotiated every time a new technology changes our world.